orders can't go on in perpetuity. Well, say what? Right, but where's the middle ground? And I don't think the Supreme Court thought when they issued the Dow order that, I think they thought that people would just automatically file a lot more motions for unitary status and they wouldn't try to do good. And not that every school district has, but I think there has been some good that's come about that with that. We have been involved on the plaintiff side of school finance cases, but one of the interesting cases that we became involved in, I don't know whether you all remember, but the Nebraska legislature passed a law that was going to divide up the Omaha public schools along racial lines. This was maybe 5 or 6 years ago. And we represent Omaha public schools, and they asked us if we would work and sue the state over that law, which we brought in the Legal Defense Fund and other civil rights groups and found some plaintiffs and did in fact sue the state. It allowed them, that case never had to go to litigation, but it allowed them the opportunity to get that law overturned and to shape some things that were better for Omaha public schools. Again, it was a compromise, but it was a way to use litigation to get there. So I'm a little schizophrenic on it. I like to use litigation in terms of filing lawsuits, but in a rather limited sense, because I think they take a long time to really get what someone wants, and they're very expensive from the school district perspective.
Thanks, Miranda. My first question is actually going to go to you. Let's say that a client comes to you and they want to have their school, they want to have the schools in their district be more racially diverse than they are now. They also want to be in a position where if somebody files a lawsuit similar to that, the ones filed in Seattle and Louisville, that they're going to be well positioned to defend against that lawsuit. What sort of counsel do you give to that school district?
Well, first of all, you did mention that we represented the Seattle Public Schools in the PICS. I call it the PICS case. Other people call it by whatever name, but it's PICS to me. And so what I would do is explain to them what the PICS case is and what the PICS case isn't. And as I see it, it's a 414 decision. I understand dicta and all the legal terms, but I see it as a 414 decision. We were writing for Justice Kennedy. That's who we wanted to go at. Everyone obviously was writing for Justice Kennedy, but we were clearly focusing on Justice Kennedy. And so what I try to do is explain to them is that the case is much narrower than the New York Times or the media has reported, because of course what the press has said, including some of the best reporters for the New York Times, is, well, the Supreme Court has ruled that you can never use race as a factor. I mean, I was on the phone with some of those folks that day, and I was like, have you guys read this opinion? Because, of course, they were. And one reporter, I said, well, where did you get that information? Well, I talked to another reporter. Great reporting. You should read the opinion. But when I'm working with a school district, I try to explain that case was about individual choice. And so that may not have any impact on what you want to do. So, John, what I would want to know is, well, in terms of student assignment, are you going to use an individual choice plan? Do you want to draw boundaries? Do you want to do a combination? What do you want to do? Because I think different rules apply. And I, for many years with school districts, way before the Seattle case, in doing geography or in doing drawing boundaries, I had school districts look at race, but they also look at socioeconomic factors. They also look at the percent of ELL kids, percent of special ed kids. You look at a whole range of factors because diversity is very broad. So I'd want to know, what kind of student assignment plan do you want to do? Do you want to redraw all your boundaries? Do you want to have a total choice plan? Are you just going to do one school? And of course the one school is going to affect that. But I also would say to them, which is a big thing that we spend a lot of time, what are your educational objectives? Why do you want to do this? And what I hope I'm going to hear is we want to improve achievement, because we've got to write those things first. So it's not just, we don't fall into the trap. Whatever the Chief Justice meant about racial balance, which I have no idea what he meant. I don't know what the term really means. I want to know, why are you doing this? Are you doing this because you think that if kids go to school with kids who are different than them, that will bring about improved achievement? Are you doing this because what we know is when we get high concentrations of poverty and we get high concentration, I'm going to lump minority teachers together, we tend to get higher teacher turnover and those sorts of things, and then we blame it on the kids, right? So are you doing it because you want to control the teacher turnover in your school? Why are you doing that? And make them articulate the reasons that they're going to do it. Whether they use race or not, they need to articulate the educational reasons. So that's clearly, I would ask them, what kind of a student, how much, what is your student assignment plan going to look? Why are you going to do this? Explain the case law with them. And then of course, I would say to them, there are many race-neutral things that you can use, and which is geography, SES, mother's level of education, suburban, urban, rural, all of those things, and then articulate an educational reason for why you're using one of those race-neutral factors, and see what the plan would look like based on that. I do think, just as an aside, I think the DOJ OCR guidance was helpful. I don't agree with everything that they said, but I do think it's a useful piece. And I would also commend to people to look at a new piece that's come out, and I haven't read the complete report, but did you all see the Brookings study that came out? Mm-hmm. Brookings did a study that came out about 2 weeks ago, and it was on zoning and educational equity. And so by zoning, they meant drawing student assignment plans, and then the achievement gap. So they said, well, let's look to see where there is an achievement gap, and they have 100 school districts / metropolitan areas, so it's not clean based on school districts unless you've got a county-wide school district. So 1 to 100 being the best, 1 being the worst. Stamford, Connecticut, I think was either number 1 or number 2. The one, El Paso was number 100, which I think is interesting, and I haven't gotten into that. I do know number 99, which is why I want to talk about it. Number 99 is Lee County, Florida. Anyone been to Fort Myers? Countywide system. Really interesting system. I started working with them in the early 90s. And they were under a desegregation order, and we were opening new schools all the time and pulling our hair out of drawing boundaries, had death threats over some of the boundaries that we recommended, including we were going to move white kids across the Caloosahatchee River for the first time. And we all had death threats, and the FBI was involved, so it was very serious. And one day, the board president came to me and said, I don't want these boundaries anymore. I want to do controlled choice. And I said, well, if you're going to do controlled choice, you're not going to get out from under this court order anytime soon, because it's a new plan. And now we're going to have to show LDF that this plan has worked, and it's worked for a reasonable period of time. Don't care, that's what we want to do. Which was interesting because Fort Myers is not liberal. Guys, if you know this place, it's not a liberal place. And so we went about designing a controlled choice plan while they were under court order. We used that to get the school district out from under court order. Once they became unitary, they've continued controlled choice. They use free and reduced meals, or SES, as the factor now, as well as some proximity and other things. But isn't it interesting that they're number 99? And most of their schools are A schools, which is the ranking. They grade their schools in Florida, which is controversial. But most of their schools are A, and the superintendent who left a year ago would say that he's convinced it's because of the choice plan, and it ties right in with the Brookings study, and I'm dying to read the whole report.
So, Art, I noticed that you've been scribbling all sorts of notes. I wonder if you have some...
It was making me nervous.
I wonder if you have some thoughts about this
So
issue.
I'll put you at ease. I agree with everything Marie said. How's that? Really only 2 fundamental points I would just sort of accentuate off of what her very wise advice in sort of where you would press a district in a situation like this. One, just to take one step back, there is a remarkable shift that we are living day in, day out, and I think sometimes I still find myself taking it for granted that everyone is quite attuned to it. We are in a world where most of the, I shouldn't say most, an increasing number of the questions about race and racial equity tend to center on achieving educational outcomes as opposed to, in a real sense, remedying some specific harm or wrong of the past. And so, stated differently, it is a shift from the remedial focus to the what are you trying to achieve as educational outcomes. And that dovetails with No Child Left Behind and the light on disaggregation of student performance by race, ethnicity, and the like. That shift is a really important shift to pay attention to in light of the very correct first question Marie poses, which is, what is your objective? What are you trying to achieve? And as obvious as that simple question is, I can't tell you the number of closed-door meetings with very smart people, with some of them with PhDs. You ask that question and they go, wow, we've never really thought about that with any rigor. This is an area where I passionately believe we should not run away from the rigor that the court articulates. We should embrace it. Because when you translate the legal standards into educational questions, they make sense. And while we may not all agree with everything the court has ever said on these issues, it's a doable, workable standard, but I think we make a mistake if we sort of run from it. And so being aware of the more central education question of what am I trying to achieve, if it's closing achievement gaps or addressing other issues on that front, is really important. The other sort of central question, and it's sort of a level of granularity below where Marie hit, that I would press hard, and for me it is the singular, or among the key takeaways from, I agree with you, it's the Biggs case.
We'll call it that going forward. We actually in our office call it that too, but.
Let's come up with better plaintiffs' names in the future. The Biggs case. And it's this. I think for decades there was a subtle undercurrent of Supreme Court jurisprudence that basically said, if you're going to use race in any form or fashion, this sort of disfavored tool that we're not willing to categorically eliminate, you better be achieving something with that use of race or you've got a problem. And as I've termed it in some things I've written, I think the court finally came out of the closet in Picks, when Justice Kennedy and the majority actually said, and I would be interested because I bet maybe their rendition of the facts isn't exactly what the facts were. So I'm going to beg that question
true.
I'm going to beg that question.
I'll give you that.
I'll beg that question for the second. But if you accept their version of the facts, the use of race in the two school districts yielded in one sort of a benefit to 3% of the student body and to others a couple of dozen students. They're saying, wait a minute, you're going through all